This is the current federal tax developments for the week of March the 17th, 2025. Current federal tax developments are brought to you by your state society of CPAs. And this week, we're going to take a look at a few things that happened in the past week. First, we're going to talk about the tax court that found a taxpayer failed to provide a qualified appraisal, losing their charitable contribution deduction. And it seems, even though the court did not actually rule on this in the end, that it's highly likely they also just simply didn't have a qualified, basically a contemporaneous written acknowledgement, which would have been fatal in any event as well. We also are going to find an estate that was found liable for a $2 million FBAR penalty that applied to the decedent, but the court did find that the surviving spouse, who also was the executor of the estate, was not herself liable for the full $2 million penalty, finding that it would not necessarily be an excessive fine if applied to her. We look at the taxpayers filing court challenges now on attempts to obtain employee retention tax credits. I want to talk about this because the cases we've talked about before this have been ones that have been simply looking to get a judgment that the IRS can't enforce the Notice 2021-20 that they issued, which I've always thought was okay, great, but that doesn't really tell us that any of your claims work. In this case, they are, at least both of the cases here, both filed by the same law firm in Ohio. The cases, in this case, they're actually asking for their refunds, which I think are the types of cases we need to see move forward. One that throws out the notice, to me, great, but that doesn't tell us how the law works. That just tells us that they've, throw out the notice, but I've never thought the notices were anything but safe harbors. So it's always been my case of, okay, we win that, so what? It doesn't mean everybody in the country gets a refund. We need to understand what it would take to get that. We also have the Fourth Circuit overturning a trial court's judgment, summary judgment to the government, finding there's a true issue of fact exists regarding whether or not the statute remains open, because it was a true issue of fact for when a request for particular government to consider an installment agreement was actually made. And that'll be an issue. That's interesting because it's going to take a look at whether or not the IRS is essentially granted what's effectively a unable to be overcome presumption that their records are correct on things like dates. And finally, a very useful memorandum issued by the IRS discussed when a taxpayer can claim a deduction if they are a victim of various scams under current law. So I want to talk about that. We've talked about the topic before. This memo really just goes along and says, for the most part, what I've been discussing and saying for quite a while about when you're going to be able to get a deduction, even under the Tax Cuts and Jobs Act rule that banned, quote unquote, personal casualty loss deductions, unquote, if they weren't from a federally declared disaster. That's all fine and good, but the problem is there is a definition of what's a personal casualty loss that applies, and it's not what you think it is. And it's basically much narrower than you think it is. There's a big hole in that definition that you can use. And so we'll talk a little bit about that. But let's go to the case where the tax court is finding a taxpayer failed to provide a qualified appraisal for their charitable contribution, and they lost their entire charitable deduction. Now, this is the case of Cade versus Commissioner, Tax Court Memorandum Decision 2025-20. The key issue: what are the substantiation requirements for a charitable contribution deduction? This is a collection due process case, or at that point, the IRS started to collect the money due. But we're still going on the back and forth about whether or not this particular contribution, doubt as to liability types of issue, or more in the case of they amended their returns to come up with this, do they actually have a reduction in the balance due? And one of the key issues is, do we even start the discussion because, did they fail to get a contemporaneous written acknowledgement, or did they fail to provide a qualified qualified appraisal? And we're going to find that the court's going to rule on the latter. They failed to provide such a thing, and that therefore, as a matter of law, the deduction will be disallowed. We will talk about why the court was very skeptical of the contemporaneous written acknowledgement, but held that, no, you couldn't use that, unlike what the district court, or what, that in essence, they couldn't use that particular attack to throw it out. That the trial, the tax court felt in this as being a motion for a summary judgment, which basically means we're going to take what each party has told us so far in their pleadings. We're going to assume they can prove everything in there. We're going to assume that in essence, every statement they made is capable of being proved. Do we know enough now just from that, for the party not moved for summary judgment, we assume their statements are all, they can prove all of that. Basically, even if they proved it, is not enough for them to carry the case, meaning that we can just stop it at this point. The court found that for the contemporaneous written acknowledgement, nope, you couldn't stop at that point. There was a question. In essence, even if I assume they can prove everything that they're claiming, then based on what I have before me right now and what they've claimed and what they therefore have to prove in addition, in order to in order to meet what they've told me they can do, then I think we got to go to trial. There's a question of fact here to be decided. And this was a claim deduction of $284,553, get the right number in there, for various donations to Victory Christian Church. So we're not talking about a small amount here. And by the way, this was basically claimed on an amended return. That's why it's coming up here as part of this situation. Now, let's talk about the basic rules for contemporaneous written acknowledgement. Okay. This is a CWA. Remember, a CWA, contemporaneous written acknowledgement, is required for any charitable contribution of $250 or more. And that has to be received from the donee organization in order for any deduction to be allowed. And the key issue here is it must contain certain statements in it, and you must have it by essentially the later of the date you filed your return, right? Or I should say by the date the return was filed. Essentially, you need to have that document in there. That's basically what we're looking at here, right? So it is, and I should say, the earlier of the date the return is filed or the due date of the return. Got that now done correctly. Now, the question in this case was there any such CWA in existence at that time? Now, the taxpayer tried to argue that the Form 8283 itself serves as a CWA, which is, I've never anybody tried that one before. But the court said, here's a problem. That, even if we accept everything else, and supposedly that the organization gave you it, I guess since it would come from the organization, even if I buy all that, the problem is nothing on that form states that no goods or services were received or provided by the donee. And so that's a serious problem. Now, they did have another CWA, and there's a lot of reasons to doubt it. The signature appears uniquely different than the signature from supposedly the same people on other documents. So that raises questions of whether they actually signed it. There's all kinds of other questions about the way it was structured, various problems with it. But the court did note that those questions regarding whether it was authentically a CWA is one that would have to wait for trial, right? The court can't just jump to the conclusion based solely on what it has before it that these, that basically, that they did not get a timely CWA. So they said, we can't end this case here, but we can go on to one other thing, because the major thing they gave were non-cash contributions, right? And this is where we get into the qualified appraisal requirements, right? Under section 170 F11 cap I of the code, it requires a qualified appraisal is the term the code uses for certain non-cash charitable contributions. Basically, those over $5,000, unless they are in certain limited categories like publicly traded securities. Okay, we have to have that. Now, the law provides that the IRS will define this by regulations. And those regulations provide that information that must be in there. A qualified appraisal must give the qualification of the appraiser themselves. Their background, their experience, education, professional memberships. They have to give information about the appraiser's qualifications specifically to value the type of property that's being given here. Whatever they might be given, why do you have the special ability to do it? Right? They have to also then give the method they used to come around at the value. Did they use an income-driven approach? Did they use market data on market data sales? Did they do replacement costs? I mean, what method was used to come to this value? You can't just pick a value out of thin air, right? That's, it's not a, even though clients sometimes seem to think when you ask them what's the value of that non-cash contribution, they look up at the ceiling. No, you can't just look up at the ceiling and pick a number out of thin air. They got to basically have a method that was being used and the specific basis for the valuation. If you're using like market data, did you use specific comparable sales? And, which ones did you use? What did you choose? How do you do that background? Now, what the court found was that the statements provided by the taxpayers in this case failed to include critical information for a qualified appraisal. Specifically, it was missing the valuation method that were being used and the basis for coming up with their valuation. Like we would say, comparable sales and the like. So these appraisals, basically they're majorly defective. And in a way, the court felt meant that clearly they were not qualified appraisals for purposes of this valuation. And yeah, it's a fatal flaw. You don't have that, you have lost these contributions, right? Now, the other problem they had was the timing of when they got this appraisal. Even if it had been a qualified appraisal, you have to meet certain timing requirements for this, right? And for a deduction as first claim on amended return, this appraisal must be received by the donor before the date the amended return was filed. So this becomes key. The date the amended return is filed is the date by which you must have the appraisal. You can't file an amended return claiming, hey, IRS, you owe us back this money, or this reduces what we owe you by this much money based on this donation of property that requires an appraisal. If you don't have an appraisal by that date, it's going to destroy it. So the documents that they gave to the court, this in front of the court, to submit as appraisals, they were dated on January 5th and 6th, 2023, which was essentially, since they filed their amended return in 2019, shall we say they were a little bit late on these. So even if the appraisal had been qualified, which the court has already ruled it's not, and that by itself is enough to disallow the contribution, it would have failed because, in fact, they didn't, get it done. They didn't have it at the time they needed to have it, right? They had it when they filed the submitted return in 2019, they didn't have the appraisal. And they didn't actually get it till around 2023, likely when it became clear they were going to trial. They're going to have to try this case, so we get these appraisals and get them done. This is true of a lot of things in charities, including like the contemporaneous written acknowledgement. And this case, Congress started imposing, and the IRS then followed on in the regs, rules that, you can't just go with your gut feel number on the return and then worry about going back and getting documentation when somebody shows up to examine you. Congress presumably put these in to penalize people who are playing the audit lottery or don't worry about having any documentation. And then if they get an exam notice, they would go out and get something and, see how much of this they could save. It's not the way it tends to work. You need this stuff in hand immediately. You can't get it later. Now, Section 170 F11 Cap 3, double I defines a qualified appraisal, right? And it means for contributions after January 1st, 2019, the regulations specify the minimum education experience requirements. that appraiser must have verifiable education and experience in valuing that type of property, or it's not going to be done. The way this can be met is by successful completion of relevant coursework and 2 or more years of experience. Kind of sounds like becoming a CPA, or earning a recognized appraiser designation for the type of property in question. Right? That's how you demonstrate your expertise and your qualifications in this case. Now, the court concluded that the taxpayers in this case provided no such specific fact to show the individuals who signed the Form 8283 met the standards for being a qualified appraiser in this case. Thus, the entire over $250,000 deduction for charitable contributions was dead on arrival. Right? We don't even have to go into whether the appraisals properly valued the property or any other document. The fact is they lack the documentation. Therefore, no deduction is allowed. Remember, charitable contributions, ever since we started, Congress got upset many, many years ago and simply made very strict documentation rules the norm for most charitable contributions. And then they added to them over time. You mess up the documentation in a contribution, or you don't get it within the right time frame, your deduction is gone. The IRS doesn't need to do anything else on exam except show that you either didn't get the proper type of appraisal or that you got whatever you got too late, which is what happened in this case. The tax court throws out the entire deduction. So that's not good. Well, let's go on now to talk about a foreign bank account penalty. This case, the estate, the guy who owed the $2 million died in the interim, but the estate of the deceased, who had offshore accounts that weren't reported, was found liable for a $2 million FBAR penalty, that applied to the decedent. Dying didn't save you in this case, is the case. Now, the case in question is United States versus Lead. It's from the United States District Court for Idaho, case number 1:22-CV-00379-AKB. Get all this in. Now, the question is whether the estate of Richard Leeds, who was the person that failed to report the account, is liable for unpaid FBAR penalties assessed against the decedent for willful failure to file reports of the foreign bank account and financial accounts, the FBARs. Right? Ultimately, the court granted summary judgment to the government against the estate, finding that Richard Leeds willfully failed to file the FBARs. However, while deciding the penalties were not grossly disproportionate, disproportional, I love that term, right? And everything you type tries to change that to disproportionate. But grossly disproportional liabilities, which is looking at the 8th Amendment's clause for excessive fines, right? Cruel and unusual punishment and excessive fines, found they weren't excessive with regard to Richard Leeds himself and therefore to the estate itself, but they were excessive, when the government tried to separately claim, against Patricia Leeds, she was in, she had culpability of some form too. Yeah, the court did not find that there was evidence that, they found that considering what the evidence showed she knew and what was involved, yeah, the court felt that penalty was absurdly high imposed against her. Now, how well that works for you when you have $2 million against the estate of your deceased spouse, it probably means there's going to be a problem. You're not going to have much left over from a deceased spouse. But, at least it helps so they can't go into her assets as well. And presumably this being in the state of Idaho, we're talking about community property is likely in this mix. Now, let's talk about the background of this. What did Richard Leeds do that amounted to, hiding his bank accounts? How did he conceal? Now, he had maintained 2 foreign bank accounts in Switzerland with EFG Bank for over 3 decades. So this wasn't a short-term deal, right? He had there for over 3 decades. Now, that bank had practices to help the U.S. clients, conceal assets. It was a Swiss bank and income, right? Bingo. That was the structure there. And we know about the Swiss bank account theories. Now, he utilized these services that were marketed to help, people, U.S. citizens, conceal information. They used pseudonyms, right? So the accounts wouldn't say Richard, they would have other names on them, but everybody knew, including the bank, that this was Richard's money, right? The parties there. He had hold mail instructions so that they wouldn't actually send mail to his address in the U.S., which could provide evidence that the accounts existed. And, and also they would disregard, and in essence, they understood that AGIST, which was supposedly a corporation, they understood fully it was his alter ego. They, in fact, basically it was there set up. So he's using all of these methods to hide the fact that he had these offshore accounts, which had a bunch of offshore income, right? And Richard, and this has tripped up people consistently. The questions at the bottom of Schedule B, actually I have 3 questions, but there's 2 yes, no's. Those are answered no, no. That's a problem. And Richard had consistently answered no's to inquiry about foreign income and accounts on tax organizers provided by his CPA. And he also signed the returns that had those boxes checked. The courts have looked to both of those. And the real problem is, especially when he answers no on the organizers, that shows willfulness. He's willfully concealing, because he was asked point blank by his CPA, do you have an interest in any bank accounts offshore, signature authority, etc.? And he said no. And therefore, knowing that that party was going to prepare a return, and knowing that that party had been, therefore, he had reason to know that that would cause that party not to inquire about additional income, or be told about the income and end up, insisting it be reported on the return or failing to do the return whatsoever. So he had lied to his CPA. By the way, that also is not terribly unknown. That's also a reason why you really, really need to insist that clients answer those questions, because otherwise you can get into a bit of a mess. If it turns out that the client just, assuming that they don't have a foreign bank account just because they didn't jam a 1099 from a Swiss bank account into their packet of data, yeah, that's probably an assumption you shouldn't be making. It's basically, yeah, there won't be a 1099. You do have to answer that question. And, it's not one you just answer no, because that gets rid of the diagnostic. That's not the way you should be doing it. You should actually know the answer to that question. But even where they haven't had evidence that somebody provided that, they've still held the clients liable because, again, Schedule B at the bottom says no and no, and those questions aren't impossible to understand. Now, you and I know that clients don't read the tax returns, but the courts are not going to get the client off on an excuse. I tell my clients, look, like it or not, courts are going to hold you liable for what's on this return. So you need to review this return, because if it turns out that there's a question like this one on there where we say, no, you didn't have a foreign bank account, and you sign the return, the court's going to say, you're supposed to read this, right? You're reading this, you're signing under penalties of perjury that you've reviewed the return, and, it's all true and complete to the best of your knowledge. That's right there on the line you signed, which they probably didn't read that either, the juror. But, sorry, it means what it says. So the clients have to be aware of that. Now, the court looked at the willfulness standard, what's a willful failure to file FBARs, and they used an objective recklessness standard, which was adopted by the Ninth Circuit Court of Appeals, which is the court to which this appeal would go. Since it's from Idaho, it would go to the Ninth Circuit. And it was their decision in United States versus Hughes. And under that standard, willfulness can be shown the filer clearly should have known, right, that there was a grave risk the filing requirement was not being met, and was positioned to very easily find out for certain if there was a filing requirement and if, we're missing things. They said, in this case, Richard's failure was willful under that test because he denied the foreign bank accounts on both the tax organizers and the returns he filed. That's an affirmative denial. And the theory being, well, you should have realized that question is being asked for a reason, and you're ignoring that. He intentionally used the Swiss bank's practices to conceal the accounts, the pseudonyms, the hold mail, and the like. He maintained a significant portion of his income in those undisclosed accounts. That was activities, these all kind of lead to the belief that he's intentionally steering this stuff offline, right? And he failed to investigate his FBAR obligations despite his CPA's advice on foreign income. He was told that he had to report income worldwide, and he just kept quiet, right? So, by the way, one of the biggest problems that Richard had was the fact that he did get professional advice. He just frankly ignored it because he didn't want to hear it. He didn't want to hear it, didn't want to deal with it. And I'm sure he thought he was smarter than the IRS. He was going to get away with this. He had worked for years basically, I believe he'd been involved with the CIA, and various other organizations. And, I'm sure he knew people that got away with this for years. That doesn't mean you will. Hate to say that. There are people that drive, well above the posted speed limits on the interstates and well above what would be reasonable speed, which is probably more important on the interstates. And a lot of them don't get tickets, but that doesn't mean you're not going to be in big trouble here in Arizona. If they catch you doing 105 going down Interstate 10 between Phoenix and Tucson, that gets you a very nasty kind of, criminal speeding type ticket. That's bad, right? And just whining that other people get away with it isn't going to really get you any sort of, shall we say, sympathy from the courts in that area. Now, the next question, though, was, okay, clearly he did a bad thing. Clearly it's there. But the Eighth Amendment to the U.S. Constitution does have a bar against, cruel and unusual punishment and excessive fines. Now, in this case, this court agreed with the 11th Circuit decision in the Schwartzbaum case that FBAR penalties are at least in part punitive. And because they are punitive, they are meant to punish. That's where the Eighth Amendment comes in. And they are therefore subjected to the excessive fines clause. And the court held that, as the Eighth Circuit held in Schwartzbaum, a fine violates the Eighth Amendment and the excessive fines clause if it is grossly disproportional to the gravity of the offense. And this was a standard found in the Bajikajan case. Sure, I murdered that name. It's a standard found there. So the question becomes now, okay, clearly he did something bad. Clearly, bad thing happened. He did something bad. And of course, Harris is also alleging his spouse was involved in doing something bad. So the question is, and the court kind of found that they both had some involvement, but now they're going to try to apportion up whether or not the $2 million fine is excessive, is grossly excessive, and therefore, grossly disproportional to the gravity of the offense, and therefore violates the Constitution. And the court came up with a split on this answer. Right. The court found the penalties were grossly disproportional as to Patricia. She was the surviving spouse and executor of the estate, because she had no knowledge of or access to the accounts. Yeah, he was hiding them from her too, right? The government could not recover penalties against her individually or from her property. So, because she had, in essence, ignorance was bliss here. Because, again, she has to be willfully involved. And they said to the extent she was involved, maybe, she should have noticed evidence or something. But she said, really, in this case, given what she was doing, given the fact she didn't question her spouse about this stuff, it was like, no, it's grossly disproportional to penalize, Patricia $2 million for, the violation to the extent she had involvement. The only involvement that the court could find, demonstrated just wasn't deep enough to justify a $2 million fine. However, Remember, she's also the executor of the estate. Now, there she failed to meet the burden of showing the penalties were grossly disproportional as to Richard, the decedent. Because the court said, look, this was clearly willful. It met every standard. It's like a $2 million penalty here is not excessive because, in essence, this went on for 30 years. It was, he evaded tons of taxes. There were all of these things going on. It's like, it's just bad, bad, bad. $2 million fine against that, not disproportionate, not grossly disproportional. And the court also concluded, the other argument they had was, it's not going to do anything after his death. It's not going to dissuade people. But the court concluded these penalties survived his death. Applying the Hudson versus United States factors, the court basically joined a number of other courts in finding that the FBAR penalties are remedial for purposes of survival, even if they also have a punitive suspect. So they help remedy and pay the government for the lost revenue, etc. So because of that, even though they have punitive impact, and obviously you're not going to dissuade Richard from doing anything at this point. He died. But they're saying it still is to compensate the government, remediate what he did. And because of that, so they have a claim against those accounts. So because of that, sorry, the estate owes $2 million. So Patricia, good news, your own property, presumably also her 50% share of the community, is not subject to this $2 million penalty, but everything in the estate is. So don't know the total facts of division here. So I can't tell you for sure how serious, whether this is good news, partial good news for Patricia. I assume it's not wholly good news for Patricia. I'm sure she would prefer to have the estate not liable at all. But that's how this case comes down. Next, we're going to talk 2 filings this week in Ohio. In 2 different cases, taxpayers filed court challenges to attempt to obtain their employee retention tax credits. And I like these cases because these are cases actually asking for the money, not just saying strike down, the IRS notices, but they're asking for the money. Okay? The 2 cases here are Hamill Manufacturing Company versus United States, or I should say filing. These cases haven't really gotten underway, basically. And R.L. Morrissey and Associates versus United States. These are in U.S. District Court for the Northern District of Ohio. They're both filed there. And so on these claims, the plaintiffs, and like I said, it's the same law firm representing both, are seeking direct refunds of amounts paid under, 26 U.S.C. 7422, the Internal Revenue Code section 7422, based on, their eligibility for the employee retention credits, the ERC. And they are secondarily asking the government to set aside and enjoin enforcement of IRS Notice 2021-20, arguing that it is invalid. Now, I've already given you my view on the notice concept here. I mean, I understand the point. I'm just not sure what the result's going to be if you win on that one, right? Okay, fine. That's not the test, right? Or at least certainly not absolutely the test, but so what is? And I've always read Notice 2021-20 more properly as a safe harbor. Like the 10% test, which we'll talk about here shortly. To me, that always was, well, if you meet that test, then, the IRS is not going to challenge you. But if you don't meet that test, that doesn't mean automatically you can't win. It probably means automatically the service is going to disallow your amount, which I understand that, but it doesn't mean automatically you won't win. And so probably, yes, they'd prefer the IRS didn't automatically disallow. I understand that point, but that doesn't mean that everybody automatically gets paid out. It just means the arguments change, which is why I'm more interested in actually asking for the money. I don't like which the cases I've had, so we've seen here in Arizona, so far haven't asked for the money. And I want a case asking for the money so we can figure out what exactly is a valid claim. What covers it beyond, if you're not covered by the safe harbor, then, can you give me some information on claims that are valid and invalid? And will we get some court decisions to back this up? So on the grounds for why they should get the money, Send me the check. Right? The old Jerry Maguire line, show me the money. Yeah, right? This is it. So Hamel Manufacturing, they claimed eligibility under government order test. Now, because this is their pleading, their initial pleading, we don't have a lot of details about the specific of the orders in question. But they do have this. They say these government orders, which they, apparently will bring forth for multiple quarters in 2020 and 21, caused a partial suspension. Both these are partial suspension cases, right? They argued the business was compelled to suspend or modify their activities due to state, local, and federal orders limiting commerce, travel, and group meetings. Those are the terms used in the statute, right? And specific impacts so they're saying we can prove, we can link these orders to our decreased machining hours because we had to do temperature checks, sanitation, increased absences due to quarantines because remember you had to keep people weren't allowed to come in. Then those result in a 10% or more decrease in machining hours. Now, of course, and they're going to say that will qualify by itself as a significant reduction. Now, they're using machining hours, and that will be what the interesting activity style test will be. But again, they're still using the 10% number, which I found interesting. Morrissey and Associates and American Ring Manufacturing, they're related. So that's why they're dual plaintiffs in the case. They're also claiming eligibility under the government orders test for the first 2 quarters of 2021. Those impacts that they're going to say, they're going to be able to link their orders, they say, to canceled trade shows, modified sales practices due to restrictions, reduced manufacturing efficiency and output due to spacing, and employee absences, presumably for the same reasons as Hamel is arguing in their case. And they also note attribution rules for parents of subsidiaries. In essence, by showing it in this one part of your business, you can expand it to all the related areas of the business. They're saying they're going to be able to do that. Now, as I say, what will be interesting here, especially in motions for summary judgment, will be what comes up, assuming these cases go to trial. Now, it is a big assumption, but I would like to see at least some. I would love to see a case come all the way through, preferably with a nice written opinion, and on a summary judgment movement initially, probably, to at least say what's possible to show. Because that's really going to be the analysis. Is it possible to use these? Or are some of these just non-starters from the beginning? I don't care what you can show, it's not going to work. Or what exactly is going on here. But I'd like to see some details. So these are the kind of cases you'd like to see. Okay. Now let's go on to the challenges on the notice under the APA. Those, I say, are of less interest to me, just because obviously it's not like everybody gets a check. Isn't this credit? That's clearly not the way the credit's written. So we still got to know what works. So this case, I love this part. And, and I do not believe those notices could ever block them if the courts ruled that these are considered to be valid. But let's talk about their notices. Now, this is more like the cases we have in Arizona that we've talked about before. They argue that Notice 2021-20 was a substantive rule subject to Administrative Procedures Act notice and comment rulemaking requirements, which the IRS did not go to. Now, if it's a safe harbor, I don't think it is a substantive rule. I think that'll be a different concept. And again, because it's not mandatory in the state. But that of course, is just my own view of it. Going to matter what the courts say in that realm. It says the IRS failed to follow these procedures, no notice of proposed rulemaking, statements of basis and purpose, or opportunity for public comment. Totally agree that's true. The IRS did not use that process. I don't think there's any question they didn't use the process. The question is whether they're required to use the process really is the big question. Now, for the relief they want is to set aside that notice is invalid under the Administrative Procedures Act and a nationwide injunction against its enforcement. Now, what that would suggest is that the IRS could not cite this as the reason to disallow something. Okay. But I think that just converts them to citing the legal analysis. That was part of the notice. It's like, because nothing stops that. If there is no substantive rule out there, we go to the text of the law. And as the court has always told us, Supreme Court has told us, the text of the law controls regardless of what anything else says. So the IRS just argues this is what the law says, and that's what you have to do. So I think it just changed the nature of that, but so they wouldn't just say you didn't follow Notice 2021-20. I'm not really thrilled the IRS when they say that, which they do in disallowances, because I don't think that notice, that I don't think notices just don't have that level of binding effects over there. The suits do not seek to enjoin tax collections or refunds for clients, but solely challenge, right? These IRS APA compliance rules for in general purposes in that area. Okay. They argue that the notice was arbitrary and capricious action. It inconsistent reasoning and lack of a reasonable explanation. Their criticism is they replaced the government orders test with a modified gross receipts test, imposing a 10% test without adequate explanation. Okay. Now, again, as I said, if you read the 10% test as a safe harbor, then arguably it's just a way to shortcut around it. If you read it as adding an option as opposed to requiring you to meet that option, that's different. I understand that that's an interesting distinction. I think it's an important distinction too. It imposed a narrow and contradictory definition of non-service wages for large employers. There are some complaints there about that. And again, I think that has always been open to litigation, which is what you do on that issue. They narrowed the ERC eligibility for businesses indirectly impacted by government orders, contrary to the CARE Act broad due to language. This one may have some, some issues, but that, the question then becomes, what does due to mean? And that's kind of a more generic open issue of what a due to test mean. If in fact no restrictions were imposed on your customers, but your customers simply, their businesses got a problem, is that good enough? And how far removed do you need to be? In essence, and of course, the ultimate question is for having yourself with a partial suspension, how much needs to happen? Is $1, right, of impact enough to give you the credit for all your employees? And if not, then where's the cutoff? That's also the key question. And again, I'm not saying that Notice 2021-20 has the real answer to that. But I am saying that, we're going to have to get an answer, right? And, denying the ERC for voluntary suspensions due to decreased demand, even commercially impractical to continue. And again, I think that is an argument over what is or isn't happening. We'll see how it goes. So again, that's there. Now, again, they want an injunction against the enforcement of this notice. Bottom line, I usually take that to mean we simply don't want the IRS to be able to deny a claim and only reference the notice as the reason you didn't meet the requirements of the notice. And I do agree the service has a tendency to do that. Just don't think that's really something the courts have generally supported as being truly there. Finally, it says with an unlawful action, they exceeded statutory authority. Congress did not authorize the IRS to issue substantive rules for the ERC, modify definitions, or alter eligibility requirements if established by statute. It says that the CARES Act and legislation are clear and unambiguous in not granting the IRS such authority. And they want, again, that injunction against enforcement. But as I noted, to me, the interesting part of these cases, and again, it's skeletal because it's the nature of these to be somewhat skeletal. But it would be really interesting to see it go forward on the issues of the claims to get me the money. I want to know what exactly works to get the client the money. I would have loved to have known this way earlier than now, but what works? Do we have case law? The problem is I knew with the short-term nature of this and how things are running, especially once Congress decided to enact a bill that required amended returns for all practical purposes by retroactively changing the law, that we weren't likely to get the case law in time for us to help us. But at this point, if a client has a claim, I still want to see the case law, right? In essence, let's see the case law, especially as slow as the IRS is moving on claims, although I have heard more reports recently of money being issued. So some people are actually getting the money now, so we'll see more of that. But it would be nice to see something actually go through and with a judge reasoning, looking at the law, looking at the facts, and giving us hopefully a nice opinion in the end about why the answers came down. We'll find out more. One problem in this case is they are asking for a jury trial. That will mean that for better or worse, and I fully understand why you'd ask for a jury trial. I think it's probably better for their clients. They're serving their clients, and they're not trying to serve the general public, right? That's not what counsel does. You serve your clients, but it does mean that we're not going to probably get a nice, complete, reasoned argument about applying detailed facts to specific law outside of motions for summary judgment, where the court simply decides there is no issue of fact to be decided, granting what's been given so far. It doesn't matter if the other parts can be proven by the taxpayer or not, right? They can't win or reverse. It doesn't matter if the IRS can prove their objections. They're not enough to overcome. So absent the summary judgment motion, I don't know that'll help. But I definitely would like to see more cases like this filed. More things like that. I realize they're expensive. Again, neither the clients nor the attorneys are in this for trying to get a public interest answer. But it would be nice to see some of these. So keep your eye on this. Hopefully we'll get some more. Next up, we have a Fourth Circuit Court of Appeal that overturned a trial court's grant of summary judgment to the government. And it found there was a true issue of facts regarding whether the statute remained open on this case or not. Because the catch is the IRS is trying to get money directly now. And the question is, did they file after their statute had closed? And the key question was, when did the taxpayer, ask for consideration of installment, basically payment options? Because again, in a collection situation, that pauses the statute. And so the key is going to be how long was the statute paused? And that's where our fight's going to come over that issue. The case in question is United States versus Stover. It was heard by the Fourth Circuit Court of Appeals. It is their case number 23-1288. Sorry about that. The issue is the timeliness of the government's lawsuit to collect unpaid taxes from the Stovers for 2007. Now, at the end of the day, the Fourth Circuit overturned the district court's grant of summary judgment to the government. It said there was a genuine issue of material fact existed regarding the dates the Stovers requested an installment agreement, because that tolls the statute of limitations if they didn't request it until the later date that the Stovers claimed was when they requested it, rather than the earlier date shown in the IRS records. Then the statute would have run out before the IRS filed the suit, which means U.S. government, tough luck, right? You waited too long. You snooze, you lose, and the government would have been snoozing in this case. So generally, this looks at the general rule under IRC section 6502A1. The government has 10 years from the date of assessment of a tax to initiate a collection suit. Right? Now, for the Stovers, and there's no question about this, everybody agrees, their date of assessment was November 24th, 2008. That means that with no tolling, if nothing tolls the statute, tolling is when the statute stops running temporarily, for some reason. There are various reasons you can, one of which, as we'll note, will be requesting an installment agreement will toll the statute. It would have closed on November 24th, 2018. So, and yes, the IRS, government filed this case after November 24th, 2018. And there's no question that it was open beyond that date. The question that's before us is how far beyond it. Now, the statute of limitations can be tolled when a taxpayer requests an installment agreement, and tolling lasts for the entire period the request is pending. This is under IRC section 6503, 6631, and those are both involved in the tolling and holding things up. So again, the statute tolls for that period. Okay. Now, the government's records, their automated records indicated a pending installment agreement on December 12th of 2008. Now, Arthur Stover testified that they, and that's a taxpayer, first contacted the IRS about a payment plan through their CPA in 2009. And the IRS records show the receipt of the power of attorney for the CPA on February 10th of 2009. So that's key because obviously, the CPA wasn't authorized. The IRS, the CPA could not present a request for an installment agreement for these taxpayers until February 10th of 2009. That's the first date the CPA was authorized to do that. So if in fact that CPA work had been when we first had the IRS being contacted to establish an installment agreement, then the statute would have essentially still been running for nearly 2 months that right now we're not accounting for. And as you might guess, those 2 months are crucial. We finally get to when the IRS filed their claim, when they filed suit. So that's going to be key, right? So they filed in 2020, right? If the request was made on December 12th, just simple math here, the tolling might have extended the statute of limitations to make the suit timely. But if the request occurred in 2009, then the tolling period may very well have been insufficient. So it is important to know which one of those dates is correct. Is it the February 2009 or potentially later date? Because again, the mere fact they got the power of attorney on February 10th doesn't mean the request was put in on February 10th, right? They note that, they put that in. It's going to take a while before everything gets done. So that's going to be the key issue. Now, the Fourth Circuit found that the taxpayer's deposition testimony directly contradicted the government's evidence. That is a dispute of material fact. For purposes of a summary judgment, the court will assume that, that the non-moving party, that is the party not seeking summary judgment on this particular matter, they're going to assume that whatever they put forward, in their documents saying that they can prove, we will show that XYZ, right? They're going to assume that they can do that. And then take a look at, well, if they do that, does that then overcome, in essence, if they did that, would that then mean at the very least, that it's not proper yet to give summary judgment? That is there a triable fact? Because they still have to prove those things, right? Unless it's been conceded by both sides. If there's dispute, then we're going to have proof, and the trier of fact's got to make a call on how that was done. So the question is, do we have a reasonable question? And the court said, look, the government's evidence says this, but his deposition establishes a direct contradiction to that date, right? Now, as noted, summary judgment, the court views evidence in the light most favorable to the non-moving party, in this case, the taxpayers, and they have to draw justifiable inferences in their favor from what's currently before the court. And it said it cannot usurp the fact finder's prerogative, quote unquote, when doing a summary judgment, even if that court's going to be the fact finder, in deciding which versions of events is more credible. This is not the point that you look at which is the more credible of the two. We just look at, we're going to make a decision. And they said the presumptions of correctness afforded government records are inappropriate for, ignoring a genuine dispute at summary judgment. And that's what's happening at this point. We have a genuine dispute on summary judgment. In essence, there is a dispute before us. And while the presumption will be, so maybe, if you can't show, unless the taxpayer can establish, basically that, right, I did at the later date, basically by at least preponderance of the evidence, if in fact it is a dead tie, the government wins this one, that's not enough, though, to give them the win at a summary judgment stage, as long as there's a reasonable dispute over the issue. So this one's helpful, if you work with statutes and those issues, to try to figure out, or at least convince a service, maybe in appeals, whatever, that, hey, wait, there actually is a statute issue here. And you need to realize there's risk of litigation, etc. About the statute issue, go into that. It does suggest you can't just say, they can't just say, hey, our records show this. You say, no, we have reasonable evidence that your records have the wrong date. And we can go down that path. Finally, a very interesting chief counsel advice here. And this discusses when a taxpayer can claim a deduction under Section 165 for a theft loss as a victim of various scams, taking into account the Tax Cuts and Jobs Act restrictions on deductions of personal casualty losses. So when can we claim that deduction? Now, this is Chief Counsel Advice 2025-11015, right? This was dated on March 14th of 2025. And this looks at deductibility of theft losses, as I noted, under Section 165 for victims of various scams. And I think you've had a lot of clients, especially being contacted via text, sometimes emails, sometimes by phone. There are various ways to do it. Texting to be the most popular way currently to do it. And they're going to analyze 5 hypothetical taxpayers with hypothetical situations that are based on situations that you probably read about in the press of how people have gotten scammed, right? And the question becomes, do they have a theft loss they could deduct in 2024 under the Tax Cuts and Jobs Act, right? The same analysis would apply all the way back to any open years, because that's the problem. A lot of people I know in tax, unfortunately, have never gone back and relooked at Section 165 and read it. And because of that, and I know we're all busy. We all have to try to keep up. They pass a major league tax law change like the Tax Cuts and Jobs Act, and you're just trying to keep your head above water, and you're reading summaries of the updates. You're reading whatever, you may get from Checkpoint, whatever their summary is of the Tax Cuts and Jobs Act, and you read their editorial on what the new law does and how it works, etc. And, you just kind of skip that, or you read, or you go to a CPE course and things like that. But, you remember, quote, rules. You may or may not have dropped into the actual law itself and followed it out. The problem here is, though, when you're talking about the big numbers, and in this case, many of these scams, they were some big numbers. You really have to go back and say, okay, is my understanding based on simply reading editorial materials or listening to CP courses, is that really what the law says? Or was that kind of a summary of what the law says? And do I need to understand? In this case, the big problem you're going to discover is, I think very few CPE courses and very few, of those write-ups of the Tax Cuts and Jobs Act ever paid a lot of attention to going beyond what was ever went into what was a personal casualty loss. The thing that attracted everybody's attention was the federal disaster area add-on that came late at the end of the Tax Cuts and Jobs Act, after a couple of hurricanes came through and everybody realized those wouldn't have been deductible. Then they went back and added that. But people just left that and didn't understand that personal casualty loss wasn't quite the same as personal investment expenses, or other things like that weren't related to a trade or business. There was a different set of rules here because 165 already had an existing definition of what is a personal casualty loss. And it's not as broad as you would assume just thinking what's a personal casualty loss. But it's more than just things that aren't related to a trade or business. That's the key. Now, the general rule under 165 for theft losses, I'm just going to deal with that pre and post TCJA, is you generally get a deduction for losses sustained during the taxable year and not compensated by insurance or otherwise under 165A. What is considered a theft is any criminal appropriation of another person's property, including theft by swindling, false pretenses, and any other form of guile. That definition came from Revenue Ruling 2009-9 and also Regulation 1.165-8D. Generally requires an illegal taking with criminal intent under state law. The state law test is important. It needs to be basically, as said, illegal under state law. Right? A criminal taking with criminal intent that's illegal under state law. So it depends upon whatever it takes I'm in Arizona, the state of Arizona, to have something rise to criminal level, right? In this concept of theft, even if we call it various other things other than theft, it's an illegal taking with criminal intent, if that's what the statute covers, then we look at that statute, we look at that statute and say, look, they violated that. That makes this a theft. That's key. Generally, you can deduct a loss first, potentially deduct the loss first in the year you discover the loss, right? Under Section 165E. Ignorance here means no deduction. And the point of that is because, especially, and with a lot of these scams, depending on how long they go on, the long con, how long it goes on, like Bernie Madoff went on for decades, you might not discover you've been stolen from for a long time. Bernie Madoff probably is the best example of that, right? He was able to keep things up and running, so people didn't realize that basically there wasn't a lot there for a long time. And to say, oh, sorry, you only did that when Bernie took your money back 20 years ago, and we don't worry about the fact you've left it on deposit for 20 years, but it really disappeared, 19 years ago, and sorry, statute's closed. No, year of discovery is your test. But there's a caveat there. Even if you've discovered it, if there is a reasonable prospect of recovery at the end of the year, you can't yet claim the deduction. So essentially, we start, once we're aware of the theft, we check the end of each year. If there is a reasonable prospect of recovery of the theft, getting the money back from the thief, then we can't yet claim the loss. However, if we get to a year where now there is no reasonable prospect of recovery, by the way, reasonable means to economically feasible. This isn't saying that if we spent $30 million, we might be able to find the guy who stole $200 from us. Yeah, that's not financially reasonable, right? So, yeah, it's got to be a reasonable prospect of recovery. So it is somewhat factual in nature. And deductible losses are limited. Oh, and by the way, that no reasonable prospect of recovery, that's under Regulation 1.165-1D2 and D3. And finally, your loss is limited to your adjusted basis in the property under Regulation 1.65-1C and 165B. These are the basic principles of a theft loss deduction under 165. Now, what was added in the Tax Cuts and Jobs Act was, specifically it said, basically for years from 2018 through 2025, which may be extended by Congress into future years as they extend the expiring TCJA items, which they are still working on. For that period of time, what is not deductible is a personal casualty loss, which would include a, quote, personal theft loss. But what you'll find out is a personal theft loss does not include a loss from a trade or business, which, okay, but people knew about it. Most people probably thought that was true. But 165 also excludes it for a loss related to any transaction entered into for a profit, income-producing property style deduction. That is where people miss it. And in one sense, you shouldn't miss it there, because if you remember, that's how we got Madoff, right? And why those qualify for NOLs, etc. Madoff was a deductible theft loss. And even if Madoff had taken place, we discovered the Madoff thefts in 2019 or 2020, they would still have been deductible losses. But a lot of people kind of assumed that Madoff-style losses were no longer considered deductible theft losses because that was personal, right? It wasn't a business account. Okay, let's talk about, there are 5 scenarios they bring out, okay? And what they do is they have 5 different categories. Now, 3 of these categories are considered to be deductible theft losses. Now, the first example was what was called a compromised account fraud. And in a compromised account fraud, right, it is what happens. Taxpayers contacted by somebody impersonating let's say their bank or their broker's fraud specialist, impersonating a fraud specialist for your bank or brokerage, who induces the taxpayer to authorize distributions from IRA and non-IRA accounts and transferred the accounts to new accounts, right? Your accounts are under attack we're the anti-fraud division. We want you to move those accounts to a new account. And let's be honest, that is something that happens with fraud, right? Let's assume a real fraud took place. I had this happen to me as I think somebody socially engineered the bank, because in theory, none of this should have been approved without me without me basically providing a second factor that was never asked for by the bank. And they didn't have my phone number, so it wasn't an SMS, traditional SMS style scam. So, and I really hate the fact that banks still use SMS, but that's beyond it. But nevertheless, when we discovered fraudulent withdrawals were hitting that account, right? And somebody tried to basically transfer it all via Zelle, to another account they controlled, which the bank did finally catch on there and stop everything. And I got texts about it, to approve it. I was in a meeting recording a tax update at the time. I was actually recording it in Armonk, New York. And so I'm sitting in the White Plains, New York airport, and I'm going over these texts suddenly, when I get there to get on the plane. Yeah, so I'm doing this. And what they did was obviously, lock down my current accounts. And then we established, and I went and saw the bank when I got back in town, and we established, brand new accounts, checking and savings, right? And we transferred those over there in person at the bank. The bank. Yes, I saw the bank, saw the banker, and I was definitely inside the bank. We did this. But now they're going to try to do it and convince you can do this offline, and maybe, oh, no, you can't go to the bank because we think some of the people at the bank are in on it. Some of the people at the bank office you go to are in on it. So, oh, no, you got to trust me, a person you've never met before. When they got it to the accounts they control, they moved those accounts overseas, and recovery thoughts are low. That was a compromised account scam. Account number 2 is a pig butchering scam, investment scam, pig butchering, which you've seen a lot of publicity about recently. In this case, the taxpayer responded to an unsolicited email advertising cryptocurrency investments. Now, that's not usually how the pig butchering scam works, but we'll talk about it because they don't want to confuse us. They want to kind of point out how the romance scams, the romance scams may be a variation of the romance scam is what's used in a lot of cases in this. But they didn't want to confuse matters, so they kept romance scams separate. In this case, you've got these, but also could be with these scams, you basically have a romance scam pulled off. But instead of doing what they're going to do for Taxpayer 4 here in the romance scam, you just discover that your new long-lost love of your life, who, by the way, you've never met. You've never been there because your long-lost love is in another country whatsoever. But you're going to meet, they're going to be coming to town real soon. But you discover that they've been really successful in cryptocurrency, and now they go on to the issue. After you make, they're going to have these cryptocurrency investments, and after you make some initial small successful investments and withdrawals, you then transfer a larger sum from either an IRA account or a non-IRA account, or both, right? Only be denied withdrawal and discover the scheme was fraudulent. The scammer is unidentified. Your prospects for recovery are low. Number 3 is a phishing scam. You receive a phishing email, and you go ahead and you provide your login credentials to your Bank of America account, your Charles Schwab account, whatever. You provide that into the account, leading to unauthorized distributions to an overseas account. Recovery prospects were low. You never authorized the transactions. Now, in these 3 cases, the IRS says these 3 all lead to deductible theft losses because they all either originate as a transaction entered into for a profit, or they relate to an account which you had established for a profit-related reason. So in example 1 for compromised account scam, they're getting your, Edward Jones brokerage account, right? And you're transferring all that stuff because you think you're talking to an Edward Jones, employee who's having you move it to a new Edward Jones account. Except you don't have any control over that. And so then it disappears quickly. Well, because that was an account you established for investment profit purposes, that will be a potentially deductible theft loss to the extent of your basis in the property. We'll talk about how IRAs get messy on this, but we're there. Okay? Right? The pig butchering scam, obvious. You put money in thinking you're buying crypto investments. You're not really buying anything. This is Bernie, but crypto, right? Basically, in fact, probably worse than Bernie because there's no real assets at all in this thing, right? So we've got that. That one will work. And then number 3, the phishing. Again, they got control of your investment account. And it's not that, the action that caused this was what was your problem. You never authorized withdrawals. These were unauthorized withdrawals from your investment accounts. That's a theft, right? And because it related to the investment accounts that were for profit, it's going to be a deductible loss. So those are 3 deductible losses. Now let's go to the last 2 scams, okay? Which unfortunately for your client, these last 2 scams are not deductible. So first is the romance scam. In this case, the taxpayer, this is number 4. The taxpayer gets an online relationship with an impersonator, right, who convinced taxpayer 4 to authorize distributions from their IRA and non-IRA accounts and transfer the funds for purported medical expenses. Oh my gosh, they can't do it. They won't be able to pay it. They're going to be ruined. They'll lose their home, etc. Everything's going to go bad. So they do that. And your client says, oh my God, I can't do this. I can't lose this love of my life. By the way, they do tend to spend a lot focusing on these, quote, romance style scams. As I said, more likely these days, romance scam is to get you into the crypto scam for number 2, the pig butchering scam. But, they do focus and have gone after those who are recently widowed or recent widowers. So, yeah, they're vulnerable. That's what they do. So, in essence, if they're saying, though, if it's the old style version, which was, oh, they're sick or they're in jail or whatever, they got, somehow they visited Turkey. They're now in a Turkish jail due to this big mess. And they need all this money or they're going to be, lifetime in prison. And you panic and you take all the stuff out. And they're going to pay you back because they have lots of assets. Otherwise, they just can't access currently. But they're going to pay you back, and you trust them because they are your love of your life, and you want them back because they're going to be coming to Phoenix here in 2 months, and you're going to meet them, and then you're going to have that wonderful wedding, et cetera, et cetera. Yeah, all that stuff. That's an option. That's one way. Or number 5, which also is used, and by the way, AI is getting very good at faking voices if it has any recording, including, to be totally honest, the recording of this broadcast is enough to let an AI fake my voice and use that as a way to persuade somebody that I'm telling them to do something. Yeah, you didn't know there was actually risk just recording a podcast like this. There are. They're contacted by an impersonator claiming to have kidnapped their grandson and demanding ransom. In essence, the impersonator, right, the fake kidnapper, does produce, supposedly their grandson, right? Basically telling them how bad this is, what's going on. They're really there. They're in big trouble. This guy is threatening them. They're going to, they're going to do all this stuff. They're going to injure, kill, etc. You need to pay the ransom. And so, the client gets all flustered because, obviously they'd do anything for the grandson, and so they go and do this. So under duress, believing that voice, they authorize distributions from their accounts, IRA and non-IRA, to an overseas account. This kidnapping was false. And again, recovery prospects are low, as it was in the romance scam. The problem here is that this one doesn't qualify. It's still a theft loss, but this one is considered a personal casualty loss under Section 165C3, because the transaction in this case, voluntary transfers based on deceit or duress in non-investment context were not entered into for a profit. I realize this seems like an arbitrary and wildly unfair distinction. And I don't think Congress thought this through, so I don't think it's intentional, but it is the way the law is written. These were non-deductible. They are the type of losses that were barred by the Tax Cuts and Jobs Act, right? They're disallowed under 165H5 for 2018 to 2025. unless you have personal casualty gain or the loss relates to a federally declared disaster area. So in this case, if you quote the medical expense payments you made to your future spouse, who turns out to be non-existent, or at least not the sex you thought they were, right? And they're really never coming to Phoenix, or the amount that you paid the kidnapper of your grandson. By the way, all this time, your grandson is perfectly safe and is nowhere near the kidnapper. And yeah, that's the problem. Yeah, we do that. So there was no threat. Sorry, but you transferred those money. Those are both personal casualty losses because, and here's the distinction, even if it was in investment accounts, you voluntarily withdrew the funds, which was your action, came to your bank account, and then you made the payment or was redirected by you to their bank account. Doesn't matter, but you didn't do that for investment purposes because you thought you were maintaining an investment account. You did it because, you were basically going to take it out of investments to use it, to allow that person to pay medical expenses or to allow, or to pay the ransom to the kidnapper. That makes it non-deductible. And, basically, so we have a bit of a problem here. It also makes it kind of interesting as to the impact on what happens with the investment account, what happens with the distribution. Let's talk about that side too. What happens about the distributions, right? Generally, IRA distributions, so bottom line, the distributions, if they have a tax consequence, it will be recognized unless the withdrawal was basically unauthorized or involuntary. So for instance, let's take those first three scams, all of which will generate a theft loss deduction, right? In the first three scams that we had, we have those three there. We talk about the issue of the compromised account scam. Well, you did transfer the funds voluntarily. That's kind of there. You did do that, but you thought they were being transferred inside the bank. I think there's going to be a very, very strong chance that you're going to be able to show that, in essence, these are transfers that were unauthorized, in which case then you don't recognize the gain. Now, great, we don't recognize IRA distribution as taxable, right? Now, just transferring funds to somebody, from your investment account usually is not a taxable transaction because you weren't exchanging it on an exchange. That wasn't the point of the transaction. But the IRA distribution would be taxable normally, but not if it was unauthorized. But the downside is if it's a traditional IRA account for which you never made non-deductible contributions, you have no basis, so you're still going to get no theft loss. If you do recognize the income, in the case of, these that are deductible, you'll get a higher basis and be able to deduct it. Now, if in fact the transfers were not authorized, and that seems very likely in number one, right? We're talking about the account, and we talk about, the supposedly you were doing the transfers, you thought you were doing an inside the bank transfer and you have an authorized transfer outside the bank. That was a more open question, but I think you at least reasonably argue a court might find with the case law on that. That'd be an unauthorized transfer and you might get out of it. But number two, the big pig butchering scam, that one's more open as to what it was. You did a fraudulent thing, but you withdrew funds. And you did put them in a non-IRA account. And that's more problem. Right? That one's probably taxable, but you're going to get a bigger deduction because once you've made the IRA withdrawal, then that's going to increase your basis. So when it was stolen, it had a higher basis. So therefore, you get a higher deduction. The phishing scam, clearly unauthorized withdrawals. You're not going to recognize the income, but again, you'll have the lower basis in the IRA accounts. Now, the real problems here are still back to 4 and 5. In 4, you took money out of the IRA account. You sent it to pay medical expenses. That's not you authorized the withdrawal. You might have authorized it under, fraudulent circumstances, you thought you were transferring it to somebody who needed it for medical care, and you just were transferring it to somebody, who's going to just take the money and run, fine. But that will be taxable IRA distribution, no theft deduction, right? That's going to be that issue. Same thing with the kidnapping. You took the money out of your IRA to pay the ransom, even in a real ransom case, that would still be a taxable distribution from the IRA, right? With no loss deduction, right? On the theft loss side of it. That's simply the way the law is written right now. So you have to kind of be aware of that. But do realize, the question of whether you're going to recognize income on the funds pulled out of the IRA account, or recognize income on amounts transferred out of an investment account, or it depends somewhat on the nature of that type of account. Again, we may very well have a taxable distribution situation too. Let's say that investment account was considered to be, it was a non-qualified annuity, and you cashed it out. That'll be taxable if you cash it out because you did the cashing out, as opposed to an unauthorized cash out. Like I said, I think the case one is where it gets messier as to which side you fall on that. I could see them trying to argue either way, right? These are all kind of our backgrounds as to how we work on that. Now, finally, you might be thinking about, hey, what about those rulings we had on Bernie Madoff, right? The Ponzi scheme scams. Because the nice thing about those was, remember I said, in order to deduct the loss, we have to first realize, basically discover we've been scammed. But we also have to wait until there's no reasonable prospect of recovery. Now, what the Madoff revenue procedures did was provided a safe harbor if you met specified conditions. Now, the specific conditions were that it had to be a Ponzi scheme, basically a Ponzi structure where, in essence, money from new victims was funding what appeared to be the distributions to the old victims. But number two, it also had to have a principal character, who was indicted or under threat of indictment. And while there was a revision made at the end after, here in Arizona, not terribly far from where I'm at right now, a major character in a scheme going on here committed suicide. Yeah, it was basically maybe about a mile and a half from here where I'm sitting. Is where he committed suicide. It was at the office. So he couldn't be prosecuted. So they did write that in too. But you have to have that with a prosecution under U.S. law. And as I'll point out, none of the examples, now I want to read the detailed case in the actual CCA, so get a hold of it. But every one of those was carefully structured so it didn't meet the requirements of Revenue Procedure 2009-20, right? In the cases of, let's say, examples one, every example except example two didn't invest in a specified fraudulent arrangement that purported to earn income, right? None of those were investing in an arrangement. Remember, we talked about the compromised account scam. We talked about the fact your credentials got phished. We talked about the romance scam and the medical side. We talked about the facts in the case of a kidnapping scam. None of those did you put money into an investment structure that turns out to be a Ponzi scheme. Now, the second one does appear to meet that requirement, right? It might be such an arrangement. It looks like it, right? You're putting money in, they give you money back. So like with Bernie, it looks like you can transfer out. So it looks like safe and good. But the problem there is the indictment side of the equation, right? It's not a qualified loss because essentially the lead figure was not charged with a crime. We can't find the lead figure. We don't know where the heck the person is, right? And they've never been charged with a crime because, they're gone. They're in the ether. They're out there. Everything was done with crypto. We can't find the lead figure, right? We don't have the lead figure. We're not able to trace it, right? The safe harbor is only available for otherwise liable theft losses, which 4 and 5 don't have. And like I said, none of them qualify under the requirements, specific rules of the safe harbor. Now, if in fact they were able to indict, find the lead figure and indict them and charge them with a crime in a pig butchering scam, then I do think you could qualify under Revenue Procedure 2009-20. The key takeaway of this is if you have any clients who've been involved in these sort of losses, get the chief counsel advice. Make sure you have a copy of that. Don't just go by the summary that if you download the documents that come with this, our write-ups. Don't just go by that. Actually, go get the notice. You want to read that carefully, and you want to follow up its legal analysis. And very importantly, go back to 165. Right? Make sure you take a look carefully and evaluate your client's situation against, using the test they're pointing out that they're using. Right? So go back and look at that. It's not enough just to read the CCA. I do strongly suggest you read the chief counsel advice, but you also follow back to what they're relying upon, the code, the regs. The chief counsel advice by itself does not establish authority, right, for you to take a position, but you can use it as basically a map to authority for a position you can argue. And then you will point out that this authority was accepted by the counsel's office. And that's likely going to help you with the agent because they're not going to really want to go back to counsel's office and say, yeah, we're going to fight this. We're going to court all the way. Counsel's not going to want to go to court on it. Presumably counsel knows this is out there. And counsel also probably disagrees with your agent because otherwise they wouldn't have written this. So kind of be aware where it's at. Right? Now, the tax consequence of the IRA distributions. Distributions are from an IRA generally includable in taxable income. If they are unauthorized withdrawals, though, they may not result in taxable income if they do not request or benefit from the distribution. A couple of cases referenced in the memo are the Roberts case and the Ballion case. Right? They note the taxpayers in cases 1, 2, 3, and 5, that in essence appears to, the lack of benefit. I already mentioned that, right? So in cases number 1 was the, supposedly the fraud officer at your brokerage or bank. Case 3 was getting fished, essentially. And case 5, which was the kidnapping requirement, they decided that all of those you could probably get out of the IRA issue in those cases if they did not request or benefit from, right? You knew what was going on, that probably there's some case law that would help you in 5. But in case 4, where you didn't essentially just, you just basically took the money and thought you were transferring money to a person, that was essentially, did not have you under duress, but just, is somebody who was, you believe was basically a romantic interest in severe need right now of cash. That one's just going to be taxable with no upside. So again, study the references in the chief counsel advice. That's probably the best way to handle this. Okay, this has been the update for the March 17th of 2025 current federal tax developments. Again, you can contact me by email, edzollers@currentfederaltaxdevelopments.com. You can try there if you have questions on this. I've already had a couple of questions on that, on the last thing we talked about from people, when I posted the update when this came out to a number of the Connect sites I'm on. So I posted, I believe, to Arizona, New Jersey, Minnesota, and Idaho. And I'm on those sites. So I've already gotten a couple of contacts on that about how it would work with a specific case. And a lot of cases, I've just kind of said, well, you kind of got to go through this, and facts matter. And you want to look at applying this, but, look at the main concepts they're using here about, and key discussion of what's considered a transaction entered into for profit, what's not. And it's not so much the actual fraud transaction, although that could be what caused you to enter for profit. And that's really case number 2, the pig butchering attack. But also, are they drawing, in essence, does this relate to an account that is investment and you believe the funds are staying in the investment account? That is the indirect way of withdrawals coming out of the investment account you didn't authorize or weren't there, versus the second part of this, where you're actually going it's basically being used in the 4th account, the medical account. Yeah, you're using it to pay medical expenses. There may not be any medical expenses, but that was your motivation, and you were taking it out. You're going to remove it from investment. You're going to take advantage of your investment, having earned this much, and you were going to then transfer it over to pay these medical expenses. That's a different concept. So it's really important to take a look at that and read 165. Seriously, got to do that. But in any event, we're here on March 17th. Happy St. Patrick's Day for those of you listening to it on the 17th. We will be back next week, and we'll talk to you about whatever's been going on here in the area of current federal tax developments.